want to thank everybody for joining us today. We have an important guest who's been in this parental rights movement for a very long time and knows it well. But before I introduce him, I just want to introduce myself. Some of you may not know me. My name is Craig DeSessa, and I am the president of the Middle Resolution Policy Network, which we have this project called the Virginia Education Opportunity Alliance that we started back in November with the fundamental goal of increasing parental rights in Virginia, especially in the education space, but also increasing the number of opportunities or the types of opportunities parents have for educating their children. And so every month we're doing this coalition call, and we're growing this coalition. We have over 60 members now, and we plan to go statewide with this, and we have initiatives making that happen. And I'll talk a little bit more about that after Will has an opportunity to speak. Today we have Will Estrada. He's the president of the parentalrights.org, which is an organization obviously focused on improving and increasing parental rights across the country. And Will's got a number of states that he's done work in, and he's working with us directly with the VEOA, obviously. And we're working on legislation right now for the 2023 General Assembly. Will, I'll let you take it from here.
Well, Craig, thank you so much for having me speak. It's an honor to be part of the Virginia Education Opportunity Alliance and to be working with all of you. I see a lot of friends. Jill Turgeon was our school board member for a long time out here in Loudoun County, and as soon as she left, things went sideways. So hope she reconsiders one day and see a lot of other friendly faces on here. I want to talk about the parental rights issue, and particularly here in Virginia, we've got a great statute 1-240.1, which is the Virginia Parental Rights Statute, Fundamental Parental Rights Statute. Our organization worked on this in 2013. Seems like ancient history. So without further ado, Craig, is it possible to share that PowerPoint? Zoom was being annoying this morning and would not let me do it. So Craig graciously agreed. I'm an attorney. I spent 14 years at the Homeschool Legal Defense Association. Thank you, Craig. I was an attorney there. I lobbied on Capitol Hill for homeschool freedom. Then I spent 4 years as a career civil servant, also known as a bureaucrat, at the U.S. Department of Health and Human Services in the Office for Civil Rights. I stayed there through the Trump administration, doing actually a lot of pro-life work, and then when the pandemic hit, a lot of pandemic response work to continue to protect civil rights. Actually, Craig, can we go back and not advance the slide just yet? We did civil rights work, and then making sure that civil rights were protected during the pandemic. And then I stayed for as long as I could. And then the Biden administration, just things were getting a little too nutty and didn't really want to do that anymore. So right after Glenn Youngkin was elected, the chairman of the board at parentalrights.org and the Parental Rights Foundation called me and said, Will, I know things are a little different in the U.S. Department of Health and Human Services than they were in the previous administration. Do you want to jump ship and come and work on parental rights issues? And I had to think about it for maybe 10 seconds before I said yes. And so since November of 2021, I've been the president of parentalrights.org and the Parental Rights Foundation. We're a nationwide organization. We're headquartered here in Loudoun County, so Virginia is near and dear to my heart. Well, want to jump in, just kind of give a quick framing of what are parental rights when we talk about parental rights, when we talk about parental rights being fundamental. So Craig, if I can ask you to advance the slide, thank you. There's 4 that I would say seminal Supreme Court cases where the Supreme Court basically enshrined parental rights as a fundamental right. Now, interestingly enough, parental rights are not in the text of the U.S. Constitution. Actually, when Mike Farris founded parentalrights.org in 2007, 15 years ago, the mission was single focused to just put a parental rights amendment into the U.S. Constitution. We've done a lot of work on that. We've not stopped our work on that, but we have not been able to do that in 15 years. Constitutional amendments are difficult. And so when I came in, I said, yes, we're going to continue to work on this. But we're also in the meantime going to work on state legislation. We're going to build on the work that the previous president had done. We've done litigation as well. And so we haven't taken our eye off the ball, but we are continuing to do other work as well as state legislation that will continue to protect parental rights. So parental rights are not in the black and white of the Constitution because, when our founders drafted the Constitution, what was the purpose of the Constitution? To rein in the scope and power of the federal government. In fact, that was the crux of the debate when the Constitution was ratified, of whether we even needed a Bill of Rights. And the founders who said, yes, we need a Bill of Rights, said, we understand that the purpose of the Constitution is to limit the government, not to give rights to people. But they said, we realize that government can encroach on our fundamental liberties. And so we want to enshrine certain fundamental rights, which are so important, we're going to put them into the Bill of Rights. And I'm very glad our founders did. Think of where we would be today if we didn't have a Second Amendment or a First Amendment protecting free speech and the right of people to petition government and religious exercise, and then the Second Amendment, and then the Fourth Amendment protecting our rights to be secure in our persons, houses, our property and effects. The Fifth Amendment, the right to be free of self-incrimination. So I'm very grateful that our founders prevailed and that we put in the Bill of Rights. But for the first, I'd say 150 years of our country's history, there really was no opportunity for the U.S. Supreme Court to apply parental rights because our government, whether at the local level, state level, federal level, respected parental rights. And that really began to change in the turn of the century in the 1900s. And remember, pre-World War I, post-World War I, there was a lot of immigration, particularly Roman Catholic immigrants, Jewish immigrants, poor Eastern European immigrants who were fleeing repression and the growth of tyranny, and of course, World War I. And the sad thing when you think of that in this time in our nation's history was there was a lot of anti-Catholic bias. You had the Blaine amendments, and Senator Blaine had tried to put a constitutional amendment prohibiting government funds going to private schools. It was anti-Catholic dogma that was the main direction in that. That constitutional amendment failed narrowly, and then they worked on state legislation, actually. And so the Blaine amendments, which are pretty much teetering right now, the U.S. Supreme Court has struck them down individually, and we're basically, all that's left for the Blaine amendments is the crying, I think. But they're on their last legs, thankfully. But I want to talk about Meyer versus Nebraska. That was the first U.S. Supreme Court case where the U.S. Supreme Court applied parental rights as a concept to a state law. And Craig, if you can advance the slide, the background is what I talked about, xenophobia. And Nebraska in this case had passed a law that prohibited the instruction of children below a certain grade level in a language other than English. And so Mr. Meyer was actually teaching a young immigrant child, a 10-year-old, to read, and he was a German immigrant, this 10-year-old child, and Mr. Meyer was actually teaching him, it was a one-room schoolhouse, to read the Bible, and it was a German Bible. And Mr. Meyer was prosecuted by the state of Nebraska. He appealed. The case went all the way up to the U.S. Supreme Court, and the U.S. Supreme Court struck down Nebraska's law. And I love this sentence that they have, and I want to read it for you. The Supreme Court said, "The individual has certain fundamental rights which must be respected. Without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men." So next year will be 100 years since the Supreme Court's first decision on parental rights in Meyer versus Nebraska, and it was a strong decision. So if we can advance to the next slide, 2 years later, and again, it was kind of the same background of states trying to restrict parents' ability to educate their children. It was in the context of education, actually, that these first parental rights cases came to the U.S. Supreme Court. And Oregon had passed a law that restricted parents from sending their children to private schools. 2 private schools, and the parents in the private schools filed suit. Society of Sisters was a Catholic private school. There was also a non-sectarian, it was actually kind of a military boarding school that filed suit as well. Society of Sisters, the Roman Catholic organization of nuns, that was this Oregon private school. They got the top billing in the decision. And so in Pierce versus Society of Sisters, the U.S. Supreme Court struck down this Oregon law, and the Supreme Court said the following: the fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. Let's fast forward to the next case. If you can advance the slide, Craig. The next one that was a really preeminent parental rights decision that came out of the U.S. Supreme Court, again in the context of education, was Wisconsin versus Yoder. And this is interesting in that the states after Wisconsin versus Meyer versus Nebraska and Pierce versus Society of Sisters had kind of backed off that anti-Catholic, anti-immigrant approach towards trying to restrict parents. We had the first Catholic president, John F. Kennedy, and you remember in 1960 that there was a lot of controversy over John F. Kennedy running as someone who was a Roman Catholic adherent, and he had to do these arguments of, no, I'm not going to swear allegiance to the Pope. I'm an American. I'm a Navy veteran. I'm going to follow the Constitution. And so some of that anti-Catholic dogma had backed off, and Wisconsin versus Yoder was a case that dealt with Wisconsin's compulsory attendance law. And there were actually several families. They were Old Order Amish and they were Mennonites who were prosecuted because they did not want their children to go to public school after the 8th grade. They said they can read, they can write, they can be productive members of society after 8th grade. We want our children to stay home and learn our ways, learn our faith. There's no need for them to attend public school after 8th grade. And they were prosecuted. They were convicted of failing to follow the compulsory attendance law, and the jury just gave them a very small slap on the wrist of a $5 fine. And when we think of Amish and Mennonites, they're non-resistant. These families were actually planning on just paying the fine, and it was another Mennonite lawyer who said, no, this is a very dangerous precedent for parental rights. Please challenge this. I'll represent you. The case went up to the U.S. Supreme Court, where the U.S. Supreme Court struck down Wisconsin's compulsory attendance law as applied to these families, so as applied to these Old Order Amish and Mennonite families, and upheld them. It was a really good decision for parental rights. Actually, around this time, homeschooling was first starting to come back. Of course, in the founding of our country, almost everyone homeschooled their children. But homeschooling was starting to come back, and many of the original homeschooling families relied on Wisconsin versus Yoder and what the Supreme Court had said. And so what the court said is, quote, this case involves the fundamental interest of parents as contrasted with that of the state to guide the religious future and education of their children. The history and culture of Western civilization reflect a strong tradition of parental concern for the nurture and upbringing of their children. This primary role of the parents in the upbringing of their children is now established beyond debate as an enduring American tradition. And then as recently as 2000, if we can advance the slide to the Supreme Court case of Troxel versus Granville, the U.S. Supreme Court again reiterated this. Troxel versus Granville is interesting in that it was a grandparent visitation case, not an education case. The U.S. Supreme Court struck down Washington's grandparent visitation statute because they said it did not adequately protect the fundamental rights of parents. And here's what the U.S. Supreme Court said, quote, the liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court. The court then went on for several paragraphs talking about all the U.S. Supreme Court precedent, starting with Meyer versus Nebraska in 1923, and then coming all the way up to 2000, and went through these cases and then said, quote, in light of this extensive precedent, it cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children, end quote. A strong case, again, reiterating that parental rights are a fundamental right. And just want to back up, when we talk about fundamental rights, when there's fundamental rights are the highest right in our country. They're afforded strict scrutiny as opposed to rational basis test or a lower level of scrutiny. So fundamental rights are those highest rights in our nation that are recognized by the Constitution, that are protected by the Constitution, and that are protected by the U.S. Supreme Court. So if we can do the next slide, that's the foundation of parental rights. And after that decision in 2000, and with the founding of parentalrights.org in 2007, our foundation was advanced later. Legislators across the country and policymakers and people like Mike Farris, who founded parentalrights.org, they said we need to take this fundamental right of parents to direct the education, upbringing, and care of their children. We need to start enshrining it in state code. And as part of that effort, in 2013, parentalrights.org, Homeschool Legal Defense Association, and others worked with legislators in Virginia to put the fundamental right of parents to raise their children into the black and white of the state code of Virginia. So this was H1642. You can see it right there up on your screen. It was approved by the General Assembly in 2013. It's been codified at Virginia Code Annotated Section 1-240.1. It's a great statute, and you can see it right here, that the Code of Virginia is amended by adding a section number 1-240.1 as follows: a parent has a fundamental right to make decisions concerning the upbringing, education, and care of the parent's child. Now, the interesting thing is when you go onto the Virginia Code in Westlaw and Lexis, you can see the second paragraph, but when you go into the Virginia Code, you don't actually see that second paragraph if you're just kind of Googling it on the Virginia webpage. But the second paragraph is just as important, because there has been some debate, and it came from the Supreme Court's decision in Troxel versus Granville of, okay, parental rights are fundamental, but do we need to apply the strict scrutiny test, compelling state interest, the highest protection for parental rights? It's a judge-made test, but what it does is it puts the burden on the government to prove that there's a compelling state interest to override a parental right in a specific situation, and that as applied to the individual parent, the individual child, it's the least restrictive means of the government achieving this compelling state interest. A good example is, think of a child removal, where social services comes in and removes a child from the home. They would only be able to do that if they show that they have a compelling state interest protecting the life or health of the child, for example, from severe harm or abuse or neglect, and that as applied to the child, it's the least restrictive means of doing that. So this second paragraph is just as important as the first paragraph. And what it says is that it is the expressed interest of the General Assembly that this act codify the opinion of the Supreme Court of Virginia in LF versus Bright, issued on January 10th, 2013, as it relates to parental rights. And I'm going to talk about that case in just a moment, because that applied compelling state interest, a strict scrutiny test, in any issue in Virginia where there's kind of a conflict between the government and the parent when it makes decisions concerning the upbringing, education, and care of the parent's child. So that was the statute. It's part of the code. And just by way of, because I love the history and I know many of you have been in these battles for years, the next two slides, Craig, if we can advance to the next slide, I pulled from Virginia legislative information, the votes, because some of these legislators are still in the General Assembly. So here was the vote when the Parental Rights Amendment, HB 1642, passed out of the Senate. You can see it was a 24-16 vote. And look, there's Dick Black. He was my senator at the time. But look on that first line, Herring. That is Mark Herring, who used to serve, a Democrat from Leesburg. I knocked on his door once when I was doing door knocking on a campaign, and came out in his shorts and t-shirt. But he once had voted in support of parental rights as far back as 2013. And then, of course, that was the year that he won the Attorney General race. That was the year when kind of everything flipped. Some of the other interesting ones, there's Jill Vogel. She voted in support of parental rights. And there's Northam in the nay. And so Ralph Northam kind of had in the media a reputation of being a moderate, but here he is in 2013 voting against the fundamental right of parents when Mark Herring is voting for them. So just some interesting things. And Craig or anyone else on the call, if you have any thoughts you want to jump in right here of just interesting things, feel free to do that, or we can of course come back to this as well. I see Craig unmuting himself, so he probably wants to say something.
No, I don't have anything specific to say about this at this moment. Obviously, it's the Republicans who support this mostly. And the number of the names on the nay side are still there. In fact, they control the Education and Health Committee. So those are challenges we face in the Senate.
Agreed. Jill has her hand up. So Jill.
Yeah. Hey, Will, thank you for this. Hey, when you were talking about this similar statute from centuries or decades ago about parental rights, they included a religious portion. I'm curious why Virginia didn't include that in the rights of parents for the religious upbringing.
That's a really good question. So the question is, why wasn't there any aspect of religious training included in the Virginia parental rights statute? And the reason is those references to religion are not in statute. Those were Supreme Court decisions where it was specifically religious families. So there really was no need to include religious training in the parental rights statute when it was passed in 2013, because it covers all parents. Those references to religion in those Supreme Court cases were just as applied to religious parents who were making those cases.
Yeah, I guess I was just wondering if it might not help support the being able to send a child to a parochial school.
I see what you're saying. I mean, you could make that argument. I would argue that the language is very clear and it protects all parents, whether they're religious or not. It protects religious parents, and so because the Virginia statute protects the right of parents to make decisions regarding their child's education, then it doesn't matter if they're putting them in a private school, a sectarian school, a religious school, a non-religious school. Their rights would be protected.
Yeah, no, I agree with you. I'm just trying to find ways to nudge people that may not see it that way.
That's a very good point, Jill. That's a good point. Let's jump to the next slide, and then we'll I want to talk more about, and Jill might want to. I mean, there's always openings for making these statutes stronger as well. So let's talk about that at the end as well. Here's the vote in the House. You can see on February 21st of 2013, it was a 59-34 vote. And not a lot of things that jumped out at me, actually, when I was looking at the vote in the House of Delegates. You can see Eileen Filler-Corn. She voted against the parental rights statute, and she's still there. She was Speaker of the House of Delegates until thankfully the Republicans took the House of Delegates. See, I say thankfully not as a partisan, but just because of protecting parental rights. And so Eileen Filler-Corn is not in the Speaker's chair anymore. All right, if we can do the next slide. So wanted to talk real quick about LF versus Bright. This was the Supreme Court case that had come out just a month prior to the vote on Virginia's parental rights statute. For those of us in Northern Virginia, it was a unanimous decision by the Virginia Supreme Court, and it was authored by none other than Justice Bill Mims. He had served for a long time here in Northern Virginia before ascending to the Supreme Court. I believe he's retiring soon from the Virginia Supreme Court. He's a personal friend of mine. He's a strong Christian. He's spoken before our Christian Legal Society chapter up here in Loudoun County. I love Justice Mims. He'll be missed on the Virginia Supreme Court. But this was an interesting case because it was not the usual parental rights case that you would think of when we went through Meyer versus Nebraska and Wisconsin versus Yoder. It was closer to Troxel versus Granville, the Supreme Court case from 2000. It was a case dealing with Beverly Mason. She was the mom, and William Bright. They had a long-term relationship. They were unmarried. They lived together as an unmarried couple for several years. They wanted to have a child together, unable to conceive naturally. Mr. Bright became a sperm donor, in vitro fertilization, and so they had a child. And then after the child, they're like, oh, everything's good. They're having a relationship. They're saying we're the mom and dad. And then about a year after a month after the child was born, they separated. I'm sorry, 4 months after the child was born, they separated. And then a year after the child was born, the mom, Beverly Mason, cut off all contact with the dad. And he was distraught. He said, I want to be able to continue to see my child. He filed suit. The lower court ruled for the dad. The mom appealed to the Virginia Supreme Court, and the Virginia Supreme Court affirmed and said, no, he is the dad. And there was a sentence where they went into parental rights. And this is the sentence that I broke out. Most of it was looking at the donor and in vitro fertilization statutes in Virginia. But this sentence is so important. That's why that inclusion in Virginia's parental rights statute is so important. Quote, where the Supreme Court of Virginia said, quote, the relationship between a parent and child is a constitutionally protected liberty interest under the Due Process Clause of the 14th Amendment. Indeed, the Supreme Court of the United States has characterized a parent's right to raise his or her child as perhaps the oldest of the fundamental liberty interests recognized by this court. And the citation was to Troxel versus Granville. Any statute that seeks to interfere with a parent's fundamental rights survives constitutional scrutiny only if it is narrowly tailored to serve a compelling state interest. That's the compelling state interest right there. That is that second piece of the puzzle that protects parental fundamental rights. And so when we as lawyers or as policymakers are looking at state action or even a Virginia school district or a social services agency, a county social services agency in Virginia that's relying on a statute to come into a family's home, that sentence right there is key. You can replace statute to any government action in Virginia that seeks to interfere with a parent's fundamental rights survives constitutional scrutiny only if it is narrowly tailored to serve a compelling state interest. Craig, if you can advance to the next slide, that's Virginia's fundamental parental rights statute, and we've since slightly modified it. This is our American Legislative Exchange Council model legislation that we have. Section 1 says the liberty interest of a parent in the nurture, education, care, custody, and control of the parent's child is a fundamental right recognized by the U.S. Constitution and the Constitution of the state of blank. So this is something we're working with policymakers around the country to advance. And then Section 2 is exactly what is Section 2 in Virginia, is the LF versus Bright. We're just breaking it out because not every state has that LF versus Bright decision that the Virginia Supreme Court had. So Section 2 of our model bill says no agency or officer of the state, nor any agency or officer of any subdivision of the state shall infringe fundamental parental rights except as provided by law, narrowly tailored to meet a compelling governmental interest by the least restrictive means. So Virginia is exporting freedom and fundamental parental rights. That model that we have in Virginia, if we can advance to the next slide, is very similar to the ALEC model bill. I was just down at the American Legislative Exchange Council in Atlanta. It's a great organization. I don't know if anyone here has been there, but I actually got to chat with Barbara Comstock, former delegate who actually voted for the 2013 Virginia Fundamental Parental Rights Statute. Got to chat with our new Speaker of the House as well, and so it was great to see him and see many other delegates. I saw Tara Grant as well, and so a lot of Virginians were well represented at the ALEC convention. And as you can see, 15 states now have some form of either a Parents' Bill of Rights or legislation that protects parental rights as a fundamental right. Those states are West Virginia, Kansas, Michigan, Texas, Utah, Arizona, Colorado, Nevada, Virginia, Oklahoma, Idaho, Wyoming, Florida, Montana, and most recently this year, the state of Georgia and Governor Brian Kemp signed into law our fundamental parental rights bill down there as well. And we're working to make this in all 50 states. Craig, if you can advance the slide to the next one. Just before we kind of open this up for discussion about Virginia's parental rights statute, I wanted to talk a little bit about some of the other work we're doing. Our foundation currently has 2 cases pending. Mazer versus Bowser is a case that we filed in federal district court against the District of Columbia. In 2020, the District of Columbia passed a bill saying children as young as 11 can consent to get a vaccination. And actually, the way the bill was written in the District of Columbia was District of Columbia actively would hide this decision from parents. There was language saying school didn't have to notify the parents. The insurance companies didn't need to notify the parents. And so we got a preliminary injunction issued by the judge in that case, and the case is ongoing, but we think DC is going to run up the white flag. Their deadline to appeal has ended, and so I think we'll have some very good news on that case soon. And again, we're not against vaccinations, we just are against children being treated as adults. It puts children in a very difficult position of where they're being forced to make these decisions, 11-year-olds that they shouldn't be making. That's why we believe that, you know, parents have that fundamental, I would say, God-given right to raise and protect and nurture and care for their children. So when you've got state laws or District of Columbia laws that are saying 11-year-olds can consent, that's very, very troubling. And then closer to home, we have a case filed in Virginia State Court. It's Woodruff versus Herring. It's been amended now to Woodruff versus Mieres. And a few years back, under Democrat control, Virginia amended the state human rights code that made it an unlawful business practice for anyone who hires someone, and the law even says even a babysitter, to hire someone who shares their faith. And so the Woodruff family has a daughter. She's, I believe, 9 years old, who has severe needs, and the Woodruffs love her very much. And so they said, we want to hire someone to come into our home to care for our daughter, and we want to hire someone who shares our faith. And we believe that we could be prosecuted and fined under this amendment to the Human Rights Code. So we filed suit. We are in settlement negotiations with the Commonwealth of Virginia. Things changed with Attorney General Mieres coming in. So I think we'll have very good news on that lawsuit as well. And then we have numerous CPS issues. I actually just finished up an appeal, an unjust appeal of a family who was found to have medically neglected their child in Oklahoma. There's no evidence of that. In fact, they have multiple letters from doctors saying that they are great people who care for their child. We do advocacy, we do amicus briefs, we probably have some additional litigation that we'll be announcing very soon. And so that's a little bit of what we're doing at the Parental Rights Foundation.